then you be accommodated. What do we have only one matter in the list. Start the matter.
Right. Lordship,
Yes.
I have come against the judgment and order passed by learned single judge, wherein learned single judge has declined the relief sought by the writ petitioners.
Yes.
They wanted regularization of service, by virtue of the length of their service which they have rendered as a part-time employees.
Uma Devi. Paragraph 53 of
Paragraph 53 is not applicable here for the
Yes.
reason that they were appointed against no post. There was no sanctioned post, and they were appointed only on part-time basis for 3 hours a day. I take to your Lordship one of the appointment letter.
Please show us the impugned judgment.
Yes, Lordship. Yes. Impugned judgment is at page 170.
117.
170. I read it as a small judgment, I'll read the whole thing. The writ petitioner numbering 14 in number in this third round of litigation had fought for regularization of their services as permanent worker under the respondent number 2. The brief facts are that the petitioner are stated to be part-time cleaner and sweeper with the respondent corporation and have been employed on various dates commencing from the year 1985, with the last employment being in 2008, which are as follows. I skip this thing. Then paragraph. The basis of their claim is that though the writ petitioner have been working for a considerable period of time, they have not been considered for regularization against sanction post, as were done to 26 other employees, wherein for the same or similar post, the 26 employees were given regular employment. Mr. R. Jaha, learned counsel for the petitioner, has submitted that the very fact that the petitioner have rendered services commencing from 1985 and so forth will entitle them as per law to consideration for regularization as given in the judgment of Uma Devi, inasmuch as the corporation has been using their services continuously and as the same is required, there is no question of them being denied their due service benefit. It is further submitted that the stand of the respondent that there are no sanctioned post of sweeper is belied by the very fact that on an affidavit by the respondent corporation filed on 1/3/24, it has been shown that the appointment of 5 persons from the list of 26 were sweeper in a regular scale of pay under the corporation. He therefore submits that the writ petitioner have been discriminated in not being afforded regular employment in spite of their services having been used by the respondent corporation till date. Mr. V.K. Jindal, learned senior counsel, assisted by Miss B. Jarwa, learned counsel for the respondent number 2 and 3, has submitted that the terms of appointment of the writ petitioner is on a different footing altogether, and they were employed strictly on a part-time basis. It is further submitted that such employment is purely casual in nature and not against any regular sanctioned post. Further, it is submitted that the entry of the writ petitioner into service as part-time worker was also not through due selection process, which is necessary for regular employment. It is further submitted that it is not a question of the writ petitioner holding any ad hoc post on a temporary basis against any post to vest him with any right of regular employment. He concludes by submitting that the writ petitioner having no vested right are not entitled to any relief prayed for, and moreover, this being the third round of litigation on the same relief, the writ petition is barred by principle of res judicata. Hard learned counsel for the parties and seeing the material on record, admittedly the writ petitioner were employed by the respondent corporation since the date mentioned herein above, and further, the fact that they continued in employment is also not disputed by the respondent corporation. The only fact that distinguished them from other regular employees that the mode of recruitment was not through a regular selection process and further were employed only on a part-time basis. A perusal of one such appointment letter dated so-and-so of the petitioners reflect that the terms of engagement were purely on a part-time basis at a fixed rate and fixed working hour, that is only morning and evening on working day. The writ petitioner on entering this engagement therefore were well aware about the nature of the employment and also as to whether they were to be eligible for regularization. In the backdrop of these facts, the appointment of the writ petitioner as part-time workers stands on a different plan altogether from the 26 regularly appointed person referred thereto, and as such, no priority can be claimed by the writ petitioner. It is also settled law that there is an estoppel against challenging the nature of appointment once having duly accepted the same. The writ petitioner, therefore, in the considered view of this court on the terms of the employment and as the same not being against any sanctioned post nor ad hoc in nature but purely part-time, are not entitled to the relief as claimed here also. So, learned single judge declined the relief.
Yes.
After having declined the relief, the learned single judge ought to have dismissed the writ petition, but he proceeded further. However, it is this conflating to note that the respondent corporation has repeatedly maintained the stand that there are no sanctioned posts of sweeper in the corporations. As the learned senior counsel for the respondent corporation has again made submission that at the time of the writ petition was filed and before the affidavit was filed, there were no sanctioned posts, it would be expedient to reproduce paragraph 4.3 of the affidavit filed by the respondent corporation on 27/6/2022, which reads as follows. It is settled law that any regularization of services after casual engagement tantamount to backdoor entry and is against the principle of providing equal opportunity enshrined in the Constitution of India. Further, the case of the petitioner even does not fall within the exception of Uma Devi case, in as much as the exception carved out by the Constitutional Bench of India in Uma Devi case, so-and-so, is only with respect to duly qualified workmen in duly sanctioned post who had continued for 10 years or more. But in the case of petitioner, the post in question, that is the post of regular full-time sweeper or cleaner, does not even exist or sanction, and they were only engaged on temporary basis as part-time sweeper or cleaner on a consolidated fixed wage of rupees so-and-so. Hence, question of regularization of the service of the petitioner in this case does not arise. The same stand is again noticed in the speaking order dated 20th March 2020, answering the representation dated 30th September 2019.
We have read it.
So, Your Lordship, I am not agreed with the first part. I am agreed only with the observations which are made in paragraph 11.
The Lordship has applied some equitable principles
Equitable principle.
that, all right, he has admitted that they were part-time
Yes, Lordship.
and not entitled to regular employment.
Yes, sir.
But you have, this is a question of fact, which
Lordship.
has been determined by
The
first
General
court.
Civil Judge.
Yes. We sitting in appeal cannot very readily interfere with that finding of fact.
Correct.
They have been employed and they have been working for the whole day, every day of their service. That is the finding. The entire day, not 3 hours. So his Lordship has said that you pay them minimum wages which are payable to Badli workers in one day.
Your Lordship, there was no material for the single judge to note that they are working as a full-time. As on date, Your Lordship, they are still working as a part-time employees.
They must be, their employment is part-time basis, but it is being stretched to normal hours of work which is done by regular workers, maybe minimum of 8 hours. So his Lordship has said that pay minimum wages, payable per day to contract workers. What is wrong with that?
Your Lordship, provided they are working for full-time.
That is a finding that his Lordship has arrived at. They are working for the whole day.
But this is based upon no material, Your Lordship. Even in the writ petition, they have categorically stated that they are working as a part-time employees. And
Part-time employee is the nomenclature, but actual work spreads over the whole day.
that is also not spelled out in any of the pleadings, Your Lordship, which are before Your Lordship. Your Lordship will just go to paragraph 4 of the writ petition.
You come to paragraph 12.
12
of
of
the
the
judgment.
paragraph 12 of the judgment.
Last paragraph.
Though the writ petitioners, in view of the nature of their appointment, are not entitled to be considered for regularization in as much as the initial appointment is clearly as part-time workers. Is clearly as part-time workers to balance the equities, and as it has been submitted that they are engaged for the entire working day.
Yes, this is the catch. So
Yes, Lordship.
that is the finding of fact.
Your Lordship, that is what I have said, that there is no material before the learned single judge. Even this is the admitted position. Your Lordship will just see page 33 of my memo of appeal. Paragraph 4. That your humble petitioners are working as part-time cleaners and sweepers with the respondents' esteemed department, and that they were appointed in their respective posts on various respective dates. This is the, Your Lordship, admitted position. Even in the cross appeal which they have filed, they have specifically stated that they are part-time employees, working as a part-time. And even the paragraph 12, Your Lordship, which I have read it, it is mentioned in as much as the initial appointment is clearly as part-time workers. And this was the ground on which the relief is denied by the learned single judge. And another thing Your Lordship will find that they have been given the retrospective benefit on 19th April 2022. For which period they have not worked full time.
Where have you stated that you were working for the whole day? What is the period involved?
My lord,
Period of engagement.
period of engagement, my lord, from 9 till 5:30.
No, year.
Year,
When you were appointed?
30 years, my lord.
30.
Yes, my lord.
These appointments nowadays, your lordship, are outsourcers. And almost in all the offices.
How come you have got this thing that you have been working for the whole day?
My lord, at 5, we entered the office at 9 o'clock, my lord. And thereafter 5:30, we have to, impression will be taken, and thereafter we have to leave.
Attendance register is kept
There, my lord.
We will appoint their officer to go into the question whether to what extent they have worked for the exceeding 3 hours on average basis last 5 years, and in that we pay them either minimum or overtime. More appropriate would be overtime rate, at the overtime rate of the government.
Your lordship, there is no material so far these pleadings are concerned.
We will get materials.
Lordship,
Who is the secretary of this department?
Secretary, you said we have
Oh, this is a corporation.
corporation.
Ministry of Power, my lord. It comes under Union of India, my lord.
No, they are all Ministry of Power officials are in Delhi. Yes. We will ask the chairman
Lordship,
of the corporation to appoint a principal officer of the company, that is not below the rank of director.
not below the rank.
Rank of director or secretary. Company
We
secretary.
have directors, your lordship.
Yes. To go into the attendance register
Lordship,
of these employees
lordship,
for a period of 5 years
lordship,
and at an average of how much extra hours they have worked
lordship,
over 3 hours,
lordship.
and thereupon you pay them for this whole period of 30 years they have worked overtime at that rate, at the government rate.
Lordship,
Overtime per hour rate.
pro rata basis, whatever rates are there,
Per hour.
per hour, pro rata.
There the working hour is 8, overtime is after 8 hours. So here you have to take it as 3, and over 3 if they work for 5 hours, for 2 hours overtime you have to pay them.
Right.
That will go.
Before that, also there were 2 writ petition filed. If any reference is needed, if not needed, then
Sorry?
this is the 3rd round of litigation.
Yes.
In earlier in the first litigation, what has happened, this court passed the order that petitioners will make a representation before the authority, and authority will look into the matter and pass necessary speaking order. Then we have passed the speaking order.
These orders can never be fruitful. For the simple reason that you are the authority, you have denied him some relief for which he has come to court.
Lordship,
It is highly unlikely that if the court sends the matter back to him, he will change his mind.
Very true, Your Lordship.
And those orders usually produce no results. And
I understand.
multiply litigation.
Sometimes relief comes also, not that in all the cases, sometimes it comes also.
It comes, I will tell you, informally I will tell you, when the officer concerned is very minded to give relief, but according to the rules of procedure he cannot. He tells the person, you go to court and get this representation order, I will give you the relief. That is what happens. Yes, please. So we will pass that order.
Yes.
The writ was filed by 10 part-time cleaners and sweepers.
No, there are total 14 number.
14.
Where 2 persons have either left or died. One died, one left.
No, but His Lordship's judgment.
At that time there were 14. Now I'll just give.
Okay. It's 14. Working with
Respondent number 6 and 3. They are deleted.
having died.
Lordship, here I did not I don't remember whether having died or, but their names were deleted by order dated 21/8/24.
Okay. Working with the corporation since the year 1985. That's part-time. On a purely contractual appointment on an ad hoc basis. The earliest appointment was made in 1985 and the latest in 2008. As of now, 12 of them survive in this appeal. The names of the other two, which were impleaded as the respondent numbers
3
and 7.
and 6.
3 and 6.
White order dated 21/8/24.
Have been deleted by the order dated
21/8/24.
21st August 2024. Full stop. They claim regularization. Paragraph. A learned single judge of this court, by a judgment and order dated 24th April 2024, dismissed the writ application on principally the following grounds: next line without number, the respondent writ petitioners were part-time workers, their engagement is requiring them to work 3 hours in a day. Next line. They were appointed against the post against which they were appointed was not sanctioned. Next, their appointment was purely contractual, temporary, and ad hoc. Next paragraph, main paragraph without number. Hence, they had no right to regularization. However, simultaneously, with the impugned judgment and order, the learned judge proceeded to observe that the respondents had been quotation engaged for the entire working day and proceeded to direct the respondent corporation to pay them minimum wages at the prevailing rate, including arrears from the date of institution of the writ petition, that is 19th April 2022. Learned counsel for the appellants submits that the ultimate finding of the learned judge was submits that the ultimate finding of the learned judge is fraud, FLEWED, for the reason that, having held that the respondents were part-time, temporary, ad hoc workers against non-sanctioned posts, the learned judge could not have awarded them minimum wages. Moreover, this prayer was not even made in the writ petition, neither was any cause of action framed based on compensation for overtime work. Paragraph. We find merit in this submission. Although the learned judge, next line, although the learned judge had rightly dismissed the writ petition, the addendum providing for minimum wages to be paid to them cannot be supported. But we direct that the chairman of the appellant corporation shall nominate any principal officer not below the rank of director to make an inquiry relating to the average daily length of attendance of each of the writ petitioners for the last 5 years. No, not last 5 years. From the date of institution of the writ petition. The number of hours. Now, each of the writ petitioners shall be paid overtime for the number of hours this average exceeds 3 hours as an overtime calculated on an hourly basis at the state government approved rate for the whole period.
Yeah, Lordship, we are under central.
Minimum wages is state government.
We follow central government minimum wages circular. Anyway, whatever.
Paid by the central government from the date of institution of the writ. The impugned judgment, next line, the impugned judgment and order of the learned single judge stands modified to the above extent only. This appeal is about, now such inquiry shall be made upon hearing a representative nominated by the respondents and by a reasoned order within 2 months of communication of this order. This appeal is accordingly disposed of.
Your Lordship, there is a connecting cross appeal which is there before Lordship today.
The cross appeal,
In view of the order passed here,
in view of the order passed, in view of this order, the cross appeal so and so is also disposed of for the same terms.
number 1 and 2.
Yes.
Your Lordship, I pray for some accommodation, Your Lordship, in this matter. Number 1 and 2. Your Lordship, the legal counsel, Your Lordship, is out of station, Your Lordship.
This matter came up on the other day, my lord. That day also, it was specially fixed today, my lord. It's simply for condonation of delay, my lord.
Your application.
My lord.
Revision.
My lord. But the commercial court has rejected my condonation application.
Yes, yes. Where is the impute order?
It pays 118, my lord. 118.
Arbitration matter.
It's arbitration matter. It's arbitration under the old act, my lord. 1940 Act.
What is the length of delay?
My lord, from the date of knowledge is 79 days only, my lord. But here what happened, my lord, an award was passed. May I just give a list of dates, my lord, it will be very easy for place. The award was passed on 5/9/2003, my lord. And then under the old act, there was a section 30 challenge was led by us, my lord, before the civil court. And they filed an application under 1417 of the old act for confirmation of the award, my lord. The matter proceeded ex parte before the trial court, my lord.
Limitation is from the date of the award. Under the Limitation Act?
My lord, here what happened, my lord? Section 30 application was filed within limitation by us, my lord.
Okay, within time.
Within time, my lord. And now that matter was pending before the trial court for 15 years, my lord. From 2003 to now it came to be disposed of on to 2018, my lord. My lord, during that time, what happened? I was the counsel for Union of India, and exactly during the same time, my lord, I resigned from the panel. Earlier, I was Central Government Counsel, CGSC, my lord, at that point of time. So order was passed ex parte against the Union of India, my lord. Now what happened, my lord, and they obtained the decree after 4 years in 2022, my lord, and then they filed an execution petition. I entered appearance in the execution petition. Then when I sent the order to the office, it was for the first time in 2022 that they came to know that the matter has proceeded ex parte. Then immediately filed an appeal along with the application for condonation of delay, my lord, before the appellate court, my lord. Now that, in the process, counting that way, my lord, from the date of passing of the order, there was delay of about 17 some days, but from the counting from the date of knowledge, my lord, there was delay of only 17 days, my lord. Moreover, my lord, here what happened?
The additional deputy commissioner judicial is the appellate court.
Is the appellate court, my lord. Under the local rules, my lord.
And section 30, you could not appear. What is the reason?
My lord, on that day, I'll take your lordship to the reason was, my lord, around that time, I was appearing for Union of India, my lord, as Central Government Council. At that time, I was Central CGSC, my lord. I resigned from the panel, my lord. Because what happened, I was designated around that time, my lord, as senior in 2018. So it was incompatible with CGSC, my lord. So as I tendered my resignation, I transferred all the file to then ASG, my lord. And that was a very specific pleading taken by us in the condonation application. And what they do, my lord, when the 2018 order was passed, they keep quiet, my lord. They don't even inform the department that the order has been passed, please. And they get a decree after 4 years, my lord, in 2022. And my lord, the main grievance in the appeal filed by us, my lord, is that compounding of interest is not permissible under the old act, my lord. My lord, may I take your lordship to one very specific aspect, page 106, my lord. What happened during that time, my lord?
If knowledge is excluded, then what is the delay?
79 days.
No, if knowledge is...
If knowledge is excluded by
1821 days, your lordship.
then 1400 days, my lord.
1800.
1800. So. My lord, only one aspect I wanted to point out, page 106, my lord, kindly dance once, my lord.
You have anything to say?
Your lordship, that it is a admitted fact, your lordship, by that the council for the central government, your lordship, resigned on in the month October, November, your lordship, while the hearing was done on the month of July, your lordship. And your lordship, the order sheet reveals that, your lordship, that on the day that the court possibly fixed for hearing to be done, your lordship, both the parties were present in the court, your lordship. They were of knowledge, your lordship, that even in the absence of one party, didn't expect a hearing will be done, your lordship. And when it comes, your lordship, to informing the department, your lordship, regarding the decree, your lordship, there's no law telling us, your lordship, that we have to inform the department, your lordship. And when it comes to compounding of interest, your lordship, they filed a show cause in the execution case in the commercial in the commercial court, your lordship. That has been argued, your lordship, pending for orders, your lordship.
Yes, please take down. This is an application for revision.
Revision, my lord.
This is an application made by the Union of India. It is in the revisional jurisdiction of this court, comma. Asking for revision of a judgment and order dated 4th October 2024. By that order, the application of the Union of India for condonation of delay in preparing an appeal under section 39 of the Arbitration Act 1940 from an order of the court below dismissing an application to set aside an ex parte order dismissing a setting aside application in respect of an arbitral award, comma, was dismissed. There are two modes of calculation of the delay. By one mode, it is how many days? 1400 days.
1821 days, Your Lordship.
1821 days. If the other mode is taken, as suggested by Learned Deputy Solicitor General appearing for the appellant, of computing delay from the date of knowledge, it is how many days?
79 days.
79 days. Paragraph. In this case, more than the method by which the delay is to be computed or the number of days delay is not important. The delay has to be viewed from the circumstances. Paragraph. On 5th September 2003, a learned arbitrator passed an arbitral award in favor of the respondent for rupees 19,75,406 with simple interest at the rate of 12% from the date of reference, bracket, 5th October 1994 to the date of the award, 5/9/2003. if the principal and interest sum was not paid within 3 months, then further interest at the said rate till payment. Paragraph. Within time, the Union of India filed an application to set aside the award under section 30 and 33 of the Arbitration Act 1940. Next, on 17th October 2018, the application came up for consideration before the first court, learned first court. For some reason, learned counsel for the union could not be present. Their version is that the learned counsel who had been engaged had surrendered the brief on assuming a different official duty, and the union could not brief another counsel by 17th October 2018. This factual assertion is very much disputed by learned counsel for the respondent. Whatever may have been the case, no official from the appellant seems to have bothered about this matter. Eventually, on 9th September 2022, judgment upon award was pronounced by the court below. Next, on 9th December 2022, execution was levied by the respondent. However, it took the union nearly a year from that date to file an appeal before the Court of the Additional, the Deputy Commissioner, Judicial, Shillong. Together with a Section 5 application. Paragraph. It was dismissed by the learned judge by the impugned judgment and order dated 4th October 2024. no doubt that nobody can say that the learned judge committed an error by dismissing the application for condonation of delay. But look at the consequences of such refusal. Paragraph. The award with accrued interest is now for rupees 2.50 crores. Next. The award has become a rule of court and payable without any contest on merits. Next line. For inadvertence or negligence of an officer attached to the concerned department, for willful omission or negligence or inadvertence on the part of an officer attached to the concerned department, the central government would have to pay rupees 2.50 crores without having an opportunity of contesting the award on merits. Next, from time to time, the Supreme Court has said that a matter is best adjudged on merits than on technical ground. Further, if the delay is not due to any culpable conduct, the court should consider condonation actively consider condonation of delay. Of course, the condonation should not result in any unacceptable prejudice to the other side. Paragraph, I am of the view that this application under section 34, section 30 and 33 should be decided on merits. However, to ensure that no prejudice is caused to the respondent, the Union of India will make a deposit of 2.50 crores with the State Bank of India. What is the branch near High Court? Yes, main branch. In the name of the respondent, within 4 weeks from date, the State Bank, by maintaining the minimum balance to run a savings account, shall invest the entire amount in a term deposit not exceeding 5 years, earning the highest rate of interest. Full stop. The fixed deposit shall be renewed from time to time. Full stop. The respondent shall have no right of operating the account or to make any withdrawal from the term deposit. The appellate union shall pay to the respondent costs assessed at rupees 2 lakhs within 4 weeks from date. I set aside the improved judgment and order dated 4th October 2024. I am not minded to send back the application to set aside the award to the Learned First Court, to avoid, no, you begin like this, to avoid any delay, any further delay in the adjudication of this matter. I am not minded to send back the application to set aside the award to the First Court. The Court of the Additional Deputy Commissioner, Judicial Ceylon, shall hear the section 30 and 33 application. Along with the application to set aside the ex parte decree, the ex parte order passed by the learned single judge dismissing the section 30 and 33 application. These applications shall be heard on merit. Full stop. Any delay in papering either of the applications is condoned. The Court of the Additional Deputy Commissioner, Judicial Children, is directed to dispose of the application within 3 months of communication of this order.
But some corrections will be required, my lord.
Yes.
In one place, will also direct to first court, my lord, within the appellate court. Additional deputy commissioner will decide, madam. First court is assistant to deputy commissioner, my lord.
We are not sending to that court. The application to set aside the ex parte order as well as the 3033 application will be heard by the appellate court.
Right. And my lord, the deposit.
Because if you send it back to the
First
additional deputy commissioner appellate court, he has to allow that application and send it back to the lower court.
My lord.
He will hear both together.
My lord, and second correction, my lord, will also kindly seize my note. We have already deposited the money, my lord,
Right.
in the executing court, my lord. It will also kindly comes to page 3 of my note, my lord. $17,524, lord, so kindly.
How much have you deposited?
2 crore 53 lakhs, I mentioned the amount, my lord. We have deposited in the court, and court has disbursed the money to them, my lord.
Entire money?
Entire money, my lord.
You didn't say so. Everything is gone.
The deposit part will not. No, my lord. My lord,
Every part they have received.
my lord, execution petition is still pending. During the pendency of the execution petition, court directed for attachment of the office of the chief engineer, my lord. If you don't deposit the money in the court, my lord. So we have, to avoid that, my lord, attachment of the office of the chief engineer, my lord, we have deposited the money.
Why did you say that? They have taken the money already.
Subject to outcome of the appeal, my lord.
Or what outcome of the appeal? They will not be able to give it back.
My lord, undertaking has been taken from the by the court.
Undertaking what is the value?
In fact, 50% of the amount is in a fixed deposit with the court, my lord. If only 50% has been released to them, 15% is on fixed deposit, my lord.
Then you are hand in glove with them. What is the use of it? That should have been your first submission.
But in
Your officers are hand in glove with them.
absolutely not, my lord. But
This money should have been disbursed.
disbursed to them against a guarantee, my lord, in the court.
Bank guarantee.
Fixed deposit. Fixed deposit is placed with the court, my lord.
Fixed deposit till 9th December 2025, Your Lordship. We put a fixed deposit of 1 crore 27 lakhs.
What
As
was
a
the use of
condition
the
from the
money?
execution, Your Lordship. Because prior to this, Your Lordship, there was no appeal. The condemnation was not condoned, Your Lordship. So if they would have succeeded in the appeal, Your Lordship, they would have returned the money.
How much you have taken?
The entire amount, Your Lordship, about 50% has been as directed by the executing court, Your Lordship. We have placed this under fixed deposit amounting to 1 crore 27 lakhs.
Who has the receipt? Fixed deposit
Fixed deposit
receipt?
with the court, my lord. With the executing court.
And the rest you have taken.
Yes, Your Lordship.
Right, they have taken.
Then, if you win, who will get? How will you get back the 50%?
But the executing court has to take care of that part, well, because we objected with the executing court that our appeal is still pending. Please don't attach the office. Against that, we are put in such a precarious situation, my lord, that Delhi was to go to attach the office of the chief engineer, my lord. The amount has been secured by the trial court, my lord, through fixed deposit, my lord.
Then cost assessed at 50,000? Nothing. Then you write the awarded amount. was deposited with the executing court by the appellant. %50 has been allowed by the executing court to be withdrawn by the respondent. Full stop. 50% is deposited, lies deposited. With the court. According to me, the respondent is more than adequately secured by the above order of the executing court, which was not even challenged by the appellant. Then to hear it out within 3 months.
Your Lordship, one more correction. The 50% fixed deposit is not with the court, Your Lordship. You should ask Your Lordship directed by the court to keep as 50% as fixed deposit.
Certainly not. You will be directed to deposit the money you have taken. How come you were given the money?
The orders executing court, Your Lordship.
Anyway, you get the matter thrashed out on merit, then you take the whole amount. But there should be some contest. Nothing, 34 stage, nothing, setting aside stage, nothing, appellate stage, nothing, dismissed. You get the award tested, we have given 3 months time, you give him 4 weeks, 8 weeks time only. Yes. And then if it is dismissed, take the whole amount and go.
Your Lordship.
Yes.
But the item number 1 and 2, my lord.
Yes.
Both the same order will cover, my lord.
All right.
Number 3.
Right, Your Lordship.
Next. Who is item number 3?
I'm the respondent.
You are ready with the matter?
Lordship, may kindly have it some other day, Lordship, next day.
Tomorrow.
Lordship, tomorrow.
Tomorrow do it, because tomorrow also I will be, most probably be sitting singly for some time.
My lord.
On the joint pair of the parties, this application is adjourned for the day.
Number 4.
I will, my Lordship.
My lord, we have for petitioner, the respondent, you know, Mr. Contempt is not here today.
Yes, sorry?
Mr. Contempt, CJC is not present here. Otherwise, I'm ready for.
You are ready?
My Lord, let it come up after a week, my Lord.
No. You do it tomorrow.
My Lord.
Tomorrow. Same order.
Okay.